Good day, Crime Talk aficionados. Guess what? Bryan Kohberger is plotting his escape. We've got an update on the D.C. bomber. We also have an update on the Brian Walsh trial. A man is sentenced to life, and wait until you hear why he killed the woman he met on a dating app. A man casually sets fire to his girlfriend. We've got This Day in Legal History, our quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and you can check us out on any of your favorite podcasting apps. Let's go ahead and get straight to the docket today for December 5th, 2025. And first on the docket, Kohberger plotting his escape, threatening some self-harm to secure a prison transfer. That's right. In what can only be described as a calculated maneuver to alter his conditions of confinement, Bryan Kohberger, you know, the guy convicted as the perpetrator in the 2022 University of Idaho slayings, has issued warnings of self-harm to compel authorities to relocate him from his current housing unit. This development, drawn from the accounts provided by some seasoned law enforcement consultants, underscores the ongoing tension with Idaho's maximum security facility where Kohberger is detained. Now, we all know Kohberger was the doctoral student, and obviously he's been convicted, and he was sentenced to 4 consecutive life sentences plus 10 years for the burglary charge. He recently had his 31st birthday, has endured persistent disturbances from fellow detainees in the restrictive housing section known as J Block. Now, despite measures designed to isolate him for his protection, limiting him to 23 hours daily within his cell and a single hour of supervised outdoor activity, the environment has proven, well, untenable. Now, reports indicate that adjacent inmates have engaged in coordinated verbal assaults, including shouts delivered through ventilation systems and other disruptive actions that have disrupted his rest and heightened his distress. His being obviously Bryan Kohberger. Well, Kohberger has escalated his grievances by notifying correctional personnel that he will inflict harm upon himself unless transferred to a more accommodating area, such as a medical ward featuring, well, you know, larger accommodations. Now, these communications, conveyed both orally and in formal written submissions, have prompted heightened security from the staff, who have intensified monitoring protocols and restricted access to potential implements that could result in self-harm, such as writing utensils or any flexible materials. Now, the source within the facility emphasized the ambiguity surrounding Kohberger's intentions and whether the declarations represent a genuine risk or a strategic ploy for leverage remains under evaluation. And the core inquiry is whether this serves as a bargaining chip to exit J Block or signals a deeper intent. Now, he does specify harm rather than a fatal act, yet the potential for escalation apparently can't be dismissed by the prison facilities. Next thing you know, the family will be suing the jail if he harmed himself, saying that you were warned and you didn't protect him. Anyway, correctional officials operating within the Idaho's sole maximum security institution have maintained Kohberger's current placement to prioritize his security amid evident hostilities from the general population. Now, this isolation, while protective, has not quelled the underlying animosities. Sources also describe a prison culture that has rejected Kohberger's presence, with inmates expressing their disdain through relentless provocations that have persisted unabated since his arrival 4 months ago. Now, this is not Kohberger's first attempt to address perceived inadequacies in his confinement. Records from the facility reveal a pattern of formal petitions submitted shortly after his intake, citing incessant verbal intimidation and, in one instance, sexually charged threats overheard by staff. These included derogatory remarks about his person, documented in an internal incident report. A subsequent housing review in August affirmed the need for continued segregation, though Kohberger expressed aspirations for eventual integration into the communal activities of the prison. Now, the breadth of the dissatisfaction extended beyond interpersonal conflicts. Early filings highlighted discrepancies in meal provisions, such as incomplete trays and barriers to commissary services. And more recently, objections have been centered on specific dietary elements, including the variety and the condition of the fruit being served, as well as the dimensions and the positioning of his cell. Such demands suggest, and reflect a bid for, preferential handling rooted in his notoriety of being the Bryan Kohberger. Anyway, these actions are somewhat symptomatic of a broader question of dominance and recognition that he demands. And this dynamic revolves around the influence and autonomy, right? Prior to these events, he occupied a peripheral existence. The act in question elevated his profile. And by withholding, the narrative details during the court proceedings, he retains a measure of authority over the unresolved elements of the case. Now, obviously, the incidents trace back to November 13th of 2022 when Kohberger entered an off-campus residence there in Idaho, resulting in the fatal stabbing of 4 students. And genetic evidence obviously recovered from the knife sheath abandoned at the scene facilitated his arrest in Pennsylvania just weeks later. And the implement itself, the K-bar, a tactical knife obviously acquired online months prior, had not been located, and no established ties linking Kohberger to any of the victims. Now, in July, there was a plea agreement. Kohberger admitted to guilt to the 4 counts of first-degree murder, 1 count of burglary, accepting the sentence of life without the possibility of parole, and he also had to waive any appellate rights. Now, the absence of the mandated disclosures regarding his rationale or victim selection has perpetrated speculation, a void that Kohberger is going to try to exploit for his own better footing of the situation. Anyway, the Idaho Department of Corrections has not issued a public statement on these matters, adhering to policies that curtail the release of sensitive inmate correspondence. And as scrutiny intensifies, the facility grapples with balancing security imperatives. The facility grapples with balancing the security against the inmates' escalating assertions in a case that continues, obviously, to, draw our interest. You know what? Bryan Kohberger's been convicted. He's at the maximum security prison. I say get over it, dude. I've had clients that have been at the ADX for years. That's the Supermax. Get over it. You're in prison now. You're not going to get to call the shots. This guy literally thinks that he is so entitled. He needs to understand he's not running things anymore. Next on the docket, the FBI arrests a suspect in the D.C. pipe bombing case. So, federal authorities arrested Bryan Cole Jr., a 30-year-old resident from Woodbridge, Virginia, yesterday in connection with the placement of 2 pipe bombs outside the Republican National Committee, as well as the Democratic National Committee headquarters in Washington, D.C. on January 5th of 2021. Now, this development concludes a federal investigation that remained unsolved for nearly 5 years, during which no arrests had been made, despite extensive forensic and surveillance analysis. So Cole faces federal charges under 18 United States Code 844C for transporting or attempting to transport an explosive in interstate or foreign commerce with the knowledge or the intent that it would be used to damage and destroy property, under 18 United States Code 844F for the maliciously attempting to damage or destroy by means of an explosive property owned by or possessed by the United States. Now, he is scheduled for the initial court appearance today for formal arraignment. And obviously, as of the time we've done this show, he has not yet entered a plea yet. Now, according to people familiar with the investigation, Cole confessed during a multi-hour interview with FBI agents to placing the devices. He reportedly conveyed to investigators his belief that the 2020 presidential election had been stolen and that Donald Trump, rather than Joe Biden, should have won the presidency. Now, this statement provides the first documented insight into a possible motive for the placement of the bombs, plural. The device, discovered on January 6th of 2021, were constructed from approximately 1 foot long thread threaded galvanized steel pipes filled with homemade black powder and packed with metal fragments as shrapnel. Each was fitted with a white kitchen-style timer as a detonator mechanism. The first device was identified near the RNC headquarters at around 12:45 p.m., prompting a response from the U.S. Capitol Police, FBI, and technicians from the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Approximately 30 minutes later, while the initial response was underway, a second similar device was reported near the DNC headquarters at about 1:15 p.m. Both explosives were rendered safe by bomb technicians without having to blow them up. Fortunately, nobody was injured. Now, these incidents preceded the breach of the U.S. Capitol by protesters disputing the 2020 election results later that day, and the FBI had offered a reward of up to $500,000 for information leading to the suspect's identification. Well, apparently, the identification of Cole as the suspect stems from a meticulous review of evidence amassed between 2021 and 2022, which authorities revisited in recent months without yielding new leads, but confirmed prior data. Federal investigators employed a multifaceted approach, integrating financial records, digital forensic, vehicular tracking, and video surveillance to establish a direct link to Cole. Financial records from Cole's bank account and credit cards revealed multiple purchases for materials consistent with the bomb's construction. These included galvanized pipes and the white kitchen timers acquired back in 2019 and 2020, with transactions continuing even after the January 2021 placement. Now, the court's documents specify that these items matched the components recovered from the scene, including the threaded pipes used as casing as the timers employed for delayed ignition. Cell phone tower data apparently further corroborates Cole's proximity to the Capitol Hill area on the evening of January 5th in 2021, and records indicate that a device associated with him connected to towers near the placement sites during the relevant time frame, aligning with the suspect's movements as captured on surveillance. Once again, somebody took their cell phone to a crime. Anyway, vehicular evidence included records from automated license plate readers, which detected the 2017 Nissan Sentra registered to Cole with Virginia license plates. The vehicle passed a reader less than half a mile from the initial sighting of the suspect on foot at approximately 7:34 p.m. on January 5th, placing it in the vicinity before the final device was deposited. And then we got surveillance footage provided the most visually compelling evidence. Previously unreleased video from the multiple cameras in the Capitol Hill neighborhood depicted an individual, now identified as Cole, navigating the area on foot. The suspect carried a backpack, which was set down on South Capitol Street before donning glasses and scanning for observers. At 7:54 p.m., the individual approached the DNC headquarters and placed one device near the building. Surveillance then tracked the same person proceeding to the RNC headquarters, where the second device was positioned at 8:16 p.m., and the individual was attired in a face mask, eyeglasses, gray hooded sweatshirt, gloves, black and light gray Nike Air Max Speed Turf shoes featuring a yellow logo, distinctive elements that matched items later recovered from Cole's possession at the residence. Now, Cole's arrest occurred during a coordinated operation at his Woodbridge home involving SWAT teams in 2 Humvees. He resided there with his mother and worked as a bail bondsman. Neighbors described him as somewhat reclusive, frequently observed only while walking his Chihuahua in shorts, red Crocs, and headphones, regardless of weather conditions. Now, this compilation of circumstantial and some direct evidence, bolstered by Cole's confession, allegedly, formed the basis for the charges, marking a resolution to an inquiry that had previously obviously generated lots of speculation and a lot of conspiracy theories. Now, obviously, he's entitled to the presumption of innocence, and we will give him that. Particularly the fact that apparently they had all this information since 2021 and 2022, and somebody decided, the Department of Justice, not to do it. Very interesting, isn't it? Yes, indeed. So what is he looking at? Well, under the federal sentencing guidelines, we'll refer to the 2023 edition. Penalties for violation of the 18 United States Code 844 are determined by specific subsections, which give us a base offense level adjusted for factors such as intent, property type, and the risk to person. For the transportation charge under the 844D, the statutory maximum is 10 years imprisonment and a fine with a base offense level of 19 under the guidelines, 2K 1.6, unlawful receipt, possession, or transportation of explosive. This would give him an advisory range of 30 to 37 months. Well, why is that? Because he's a first-time offender with a criminal history category of 1. Subject to potential upward departures for intent to destroy federal property or create a substantial risk of injury. Well, guess what? It could go as high as 51 to 63 months, maybe even a little bit higher. Now, the attempted malicious destruction charge under 844F carries a mandatory minimum of 5 years and a maximum of 20 years of imprisonment, plus fines applicable to the attempt to harm U.S. property as well. Anyway, that sets this base offense level of 20, but enhancements under 2K 1.1 may apply for sophisticated means, like I said, federal property involved, or substantial risk of death or serious bodily injury. You get an 18-point bump up there. So for category 1, this could result in a 51 to 63 month sentence absent enhancements, but the mandatory minimum governs, and the sentence must run consecutively if multiple counts apply. Now, the judge would have to consider all those advisory guideline ranges, but it's a starting point in the sentencing range. So we'll have to wait and see how things work out. They may add charges. They may supersede the indictment. It didn't explode, so this guy's not looking at spending the rest of his life in prison, at least not as charged. Next, the Bryan Walsh trial update. Testimony in the ongoing murder trial of Bryan Walsh has centered on whether he was aware of his wife Anna's extramarital relationship prior to her disappearance on January 1st of 2023. So on the fourth day of proceedings, William Fastow, a Washington, D.C. based real estate agent who acknowledged his intimate involvement with Anna Walsh, provided detailed accounts under oath, shedding light on the couple's interactions without confirming Walsh's knowledge of the affair. Now, Bryan Walsh obviously is on trial and faces charges of first-degree murder in connection with the death of his 39-year-old wife, a Serbian immigrant and a real estate professional. Now, prosecutors allege he killed her at their home following a New Year's Eve gathering and subsequently then dismembered and disposed of her body. Now, Walsh has entered a guilty plea to related charges of misleading investigators and obviously the unlawful disposing of the human body, for which he faces sentencing after the homicide trial. Now, this is where it gets interesting. Anna Walsh's remains have not been recovered despite an extensive search. Apparently, the only one that knows is, well, maybe Bryan Walsh and his attorneys. Fastow testified that he first encountered Anna Walsh in March of 2022 during a professional transaction in which he facilitated the sale of a townhouse to her in Washington, D.C. Their association evolved rapidly from a business acquaintance to a close personal friendship marked by shared confidences and eventually physical intimacy. Activities included dinner at restaurants, visits to bars, outings on Fastow's sailboat, overnight stays at his residence, and a joint trip to Ireland over Thanksgiving in 2022. Now, according to Fastow, the relationship was not concealed from his own social circles. He disclosed it to friends and acquaintances. However, the pair did not integrate into each other's broader networks as they avoided socializing with Anna Walsh's colleagues or companions. Now, discussions about disclosure to Bryan Walsh did in fact occur, with Anna Walsh expressing a strong preference for personally informing her husband to preserve her personal integrity. Fastow recounted her stating that learning of the affair through other means would undermine her credibility in his eyes. Now, the witness described ongoing conversations about potential long-term arrangements, including the logistics of combining their respective families. Fastow emphasized, however, that no firm commitments were made, and he consistently advised Anna Walsh to resolve her marital situation before proceeding. Plans for a New Year's Eve meeting on January 4th were in place to address these matters further. The couple spent Christmas Eve 2022 together with mutual friends. Now, Fastow's last exchange with Anna Walsh was a text message she sent on December 31st of 2022. And then on January 1st, he shared a photograph of himself teaching his son to ski, accompanied by a waving emoji and a query, but received no reply. Subsequent messages and multiple phone calls on January 2nd also went unanswered, with calls routing directly to voicemail. On January 4th, Bryan Walsh contacted Fastow twice by phone. Fastow did not answer the initial call, citing his engagement at the time and a suspicion that Walsh might have discovered the affair and sought confrontation. The second call's voicemail recording was presented in court, and in measured tone, Walsh expressed well wishes, explained he was reaching out broadly due to Anna Walsh's lack of communication over several days, and inquired if Fastow had recently had contact with her. He concluded by apologizing for the intrusion and assured himself that all was likely well. At this juncture, Bryan Walsh was at his residence pending sentencing in a separate federal case involving the fraudulent sale of counterfeit Andy Warhol artworks. So, cross-examination. During the cross-examination by defense attorney Kelly Porges, Fastow conceded that no concrete timeline existed for Anna Walsh to disclose the relationship to her husband, particularly around the return home trip during the Christmas holidays. Porges pressed, there was no plan, as Anna went home for Christmas to be with the family, that she was going to come clean and tell Bryan about you. Fastow affirmed that he had no knowledge of such arrangements. Now, this exchange underscores a core contention between the prosecution's case and the defense case, whether Bryan Walsh was cognizant of the affair, potentially influencing the events of January 1st of 2023. Prosecutors have introduced evidence suggesting that Walsh accessed some of his wife's messages, though specifics remain under scrutiny. Now, prosecutors have presented forensic data from multiple devices linked to Walsh, including internet searches related to body dismemberment techniques and blood cleanup methods, and these were all conducted around the holiday period. Now, surveillance footage captured an individual matching Walsh's description, discarding heavy refuse bags in a dumpster near the family home, and a subsequent examination of a waste facility near his mother's property yielded items such as a hatchet, a hammer, shears, hacksaw, towels, and a protective Tyvek suit, cleaning supplies, and a Prada handbag. There was also boots consistent with those that Anna Walsh wore last, and a COVID-19 vaccination card bearing her name. Now, analysis by the Massachusetts State Crime Laboratory detected DNA from both Walshes on the Tyvek suit and Anna Walsh's genetic material on the hatchet, hacksaw, as well as additional tools. In contrast, the defense counsel, Larry Tipton, has characterized the case not as a premeditated homicide, but as an abrupt, unexplained demise occurring after the New Year's Eve event. Tipton depicted the Walshes as a devoted pair contemplating future endeavors, asserting that Bryan Walsh has discovered his wife's unresponsive in bed upon retiring for the night and reacted in distress. Now, testimony resumed on the trial on the fifth day with the Massachusetts State Police Trooper, Patrick Keefe, who analyzed digital records from the Walsh's devices. Prosecutors introduced text message exchanges between the couple, including discussions on work commitments, car maintenance, childcare logistics, and property listings via Zillow on Christmas night on 2022. Now, phone data indicated that active communications during Anna Walsh's drive from Washington, D.C. to their home in Massachusetts on December 25th after her flight cancellation. On cross-examination, by Tipton highlighted additional iPhone search histories such as queries for luxury champagne in anticipation of New Year's Eve, a local noodle bar, a film titled I'm Good, and Porsche models framed as benign holiday preparations rather than sinister intent. Tipton also referenced searches on December 25th concerning plane crashes and missing persons, posting they reflect legitimate worry for Anna Walsh's safety amid travel disruptions, corroborated by her own messages about the canceled flight. Keefe acknowledged he could not opine on the search's motivations and has not cross-referenced iPhone data with associated MacBook for fuller context. Now, Tipton inquired about the absence of earlier search warrants extending beyond December 25th of 2022 to detect potential premeditation, and noted that no evidence of queries related to tools or body disposals in the preceding days of December 25th through the 29th. He further questioned the lead investigator, Trooper Michael Proctor, and probed for communications between Anna Walsh and Fastow on Brian Walsh's phone, which Keefe did not recall finding. Now, the trial presided over in Norfolk Superior Court continues with the expectations of further digital forensics and witness accounts. Walsh maintains his innocence on the murder charge, and obviously that carries a potential life imprisonment if he's in fact convicted. Next, a Florida man sentenced to prison for life for killing a woman that he met on a dating app, which is a good segue before we get to the story. You should probably go to crimetalksearch.com if you're thinking about dating somebody. Don't commit dating malpractice. Go check somebody out. When you can check somebody out, you're going to get their email addresses, their social media presence. You're going to find out what is going on in their life. Are they married, divorced, criminal history, sex offender registry? Go to crimetalksearch.com. Don't commit dating malpractice and wind up in a body bag, ladies and gentlemen. So let's get to the story. A 32-year-old Florida man has been sentenced to life imprisonment following his conviction for the second-degree murder of 44-year-old Nancy Howery, a mother of two whom he had met on an online dating application. Daniel Stearns appeared in court on December 4th, where he received a mandatory life sentence for the murder count. He was also ordered to serve consecutive terms totaling another 22 years for the abuse of the dead human body and tampering with physical evidence. Now, the offense occurred back in February of 2023. Howery was last seen alive on February 15th the same year and had informed a friend that she intended to meet Stearns in Palm Bay on that particular day. She was reported missing 3 days later by her former husband after she did not arrive to collect their kids from school. Investigators from the Broward County Sheriff's Office placed Stearns under surveillance, and while monitoring him at a wooded location known as the Compound, police observed him attempting to discard evidence, leading to his immediate detention by the task force that was working on the case. A subsequent search of the area uncovered human remains that were positively identified as those of Nancy Howery. Evidence presented at trial established that Stearns shot Howery during an argument back on February 15th, and then prosecutors stated that the dispute centered on Stearns' dissatisfaction that Howery was seeing other individuals and was not adhering to what he described as his relationship rules. Following the shooting, Stearns dismembered the body, burned portions of her remains, and buried them across multiple sites within the compound over several days. The disposal efforts resulted in 5 separate crime scenes. Stearns was convicted by a jury more than 2 years after his initial arrest, and during the sentencing hearing, the prosecution described the defendant's actions as motivated by jealousy over their non-exclusive nature of the relationship. And the victim's former husband addressed the court, characterizing the killing and subsequent treatment of the body as just exceptionally brutal. The life sentence and additional terms will be served consecutively, ensuring that Stearns will basically die in prison. Next, another man, sets his girlfriend on fire. That's right. A 49-year-old man accused of fatally setting his former girlfriend on fire while she was working at a local 7-Eleven in Southern California appeared in court this week for a preliminary hearing on multiple felony charges, including murder. Please meet Jose Carlos Villanueva. He is charged with murder, arson, causing great bodily injury, mayhem, and torture in connection with the death of Amanda Buchanan. She was 44 at the time of her death on August 24th of 2024. According to law enforcement reports, the Chula Vista police responded to a structure fire at 7-Eleven. Upon arrival, officers observed heavy smoke emanating from the entrance and locating 2 female employees suffering severe burns. Buchanan, who sustained critical injuries, was carried from the store by officers and transported to the hospital along with a coworker. Buchanan succumbed to her injuries several days later. The second employee received treatment for serious burns and fortunately survived. Surveillance footage, because it's always there, reviewed by Buchanan's family members, showed the suspect entering the store carrying a container of gasoline. Buchanan had her back turned at the moment the entry took place, and a brief physical altercation ensued before the suspect allegedly ignited the gasoline. Family members stated that the coworkers attempted to extinguish the flames and they were injured in the process. The store operator used a fire extinguisher to suppress the fire after about 40 seconds of burning. Villanueva fled the scene in a BMW sedan. Police located the car using automated license plates recognition technology and arrested him later that day at a gas station about 100 miles away from Chula Vista. Court records confirm Villanueva and Buchanan had previously been in a romantic relationship, though prosecutors have not disclosed a specific motive in the public filings thus far. During the preliminary hearing this week, a close friend of the victim described Buchanan's condition in the hospital to the court. The witness testified that Buchanan was heavily bandaged, had suffered the loss of her hair, ears, and facial features, and was only identifiable by her toes. The preliminary hearing is scheduled to resume on December 17th. Villanueva remains in custody at the San Diego County Jail. Next on the docket, this day in legal history. On December 5th, 1933, Utah became the 36th state to ratify the 21st Amendment, providing the final approval needed to repeal the 18th Amendment and end national prohibition. This is one of the most consequential constitutional changes for criminal law, federal power over alcohol regulation, and state police powers. Next, December 5th, 1955, following Rosa Parks' arrest on December 1st, Black residents of Montgomery launched a citywide bus boycott and formed the Montgomery Improvement Association with Martin Luther King Jr. as president. The boycott led directly to the federal case Broder v. Gale and the United States Supreme Court's 1956 ruling that bus segregation was unconstitutional, making December 5th a key starting point in modern civil rights legal history. Next, December 5th, 1966, Bond v. Floyd, decided by the United States Supreme Court, where the court unanimously held that the Georgia House of Representatives could not refuse to seat a guy by the name of Julian Bond because of his criticism of the Vietnam War. The court ruled that legislators enjoy First Amendment protections and cannot be punished simply for expressing unpopular views on public policy. And on December 5th, 1974, Congress approved Public Law 93-512, extensively revising 28 United States Code 455 on disqualification of federal judges. The amendment adopted the now familiar standard that judges must step aside in any case where their impartiality might reasonably be questioned, reshaping federal recusal practices. I've had cases in federal court where I think a reasonable person would say that impartiality might reasonably be questioned. But the judges say, I don't believe that you should question my impartiality, and therefore the motion is denied. And next, on December 5th, 2008, O.J. Simpson was sentenced to 33 years in prison for armed robbery and kidnapping related to a 2007 confrontation in Las Vegas, specifically in a hotel room, with a minimum of 9 years before his parole eligibility. Obviously, we all know O.J.'s now dead, and he died in Florida looking for the real killer, right? Next, how about a quote of the day? How about a foundational legal quote on free speech? We love free speech. All right, ladies and gentlemen. And the first quote comes from Justice Oliver Wendell Holmes in the Supreme Court case of Schrenk v. United States, a 1919 case. Quote, the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. The question in every case is whether the words used are used in such a circumstance and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent, end quote. So this passage, while upholding limits on free speech in certain circumstances, is widely cited as articulating both the robust general nature of the protection of free speech under the First Amendment and its narrowly construed exceptions. But wait, how about a more absolute formulation that Justice Hugo Black wrote in his dissenting opinion in Koenigsberg v. State Bar of California in 1961? Quote, the First Amendment's language leaves, in my judgment, no room for Congress or the state to pass laws which abridge the freedom of speech. I believe the amendment was intended to mean what it says. Quote, Congress shall make no law abridging the freedom of speech, end quote. Now, these quotations represent two perspectives within the American constitutional law on the scope and limits of free speech protection. Obviously, we're more on the free speech side of it, ladies and gentlemen, but we also have to deal with the realities of the law. And finally, our dumb criminal of the day. Listen to this. A 32-year-old St. Petersburg woman was secured the title of Dumb Criminal of the Day after pleading no contest to falsely reporting a violent sexual assault she completely fabricated using an AI-generated image created with ChatGPT. Brooks Scheinolt was adjudged guilty Tuesday of misdemeanor false report of a crime and sentenced to probation and received a fine. How did this all begin? On October 14th of this year, Ms. Scheinolt dialed 911 to report that an unknown homeless man had forced his way into her apartment, raped her, while her infant child slept in another room. She claimed that she managed to snap a photograph of the assailant casually sitting on her living room couch after the attack. Needless to say, 7 patrol officers arrived, a detective, 6 fire rescue personnel, and a forensic technician were all dispatched to the apartment. The technicians collected DNA evidence and processed the scene for fingerprints or any other trace material. The entire case collapsed when detectives examined the photo that Scheinolt provided of the supposed attacker, a hooded white male in his 30s seated on the couch. The detectives immediately recognized the image as part of the then viral TikTok AI homeless man challenge, in which users uploaded a photo of their home interior to an AI tool, often ChatGPT, with the image generation capabilities, and a prompt to insert a realistic homeless person in the scene as a prank. Needless to say, the detectives weren't amused. They located multiple identical TikTok videos using the exact same AI-generated face. When confronted, Ms. Scheinolt first insisted she had only used AI to sharpen a genuine blurry photo of her rapist. She ultimately confessed that she had been struggling with depression and lack of sleep and wanted some attention. She told investigators she created the hoax image by typing the prompt, a homeless man, into ChatGPT. Well, needless to say, Scheinholt's deception wasted significant law enforcement resources and briefly diverted attention from the actual violent crime investigation that needed to be taking place in the city. Police reminded the public that fabricating serious felonies, especially sexual assaults, is a criminal offense and undermines legitimate victims who, in fact, do come forward. I agree. Can't believe she got away with just a misdemeanor and a fine. I would have thrown her in prison. Accusing people falsely of those types of crimes, serious offense, wasting everybody's time, energy, and effort for a little attention. Yeah, how about you go see your therapist and get some attention if that's what you need? Really? All right, ladies and gentlemen, that's all we have for today. Thanks for watching. We'll see you next time. Hope you enjoyed the show. And remember, the Constitution matters.